Hi, this is the second of two videos on Zarda and Bostick in anticipation of your assignment in class on Wednesday. Um, so, as I said in the last video, you're going to get a copy of Gorsuch's opinion for the court in Bostick, and you're going to be asked to sort of know it well, summarize it, critically evaluate it, maybe do something on a part two with a prompt or question that requires some deeper thinking. So I'm going to share screen and pick up where we left off with our discussion. Just to recapitulate a little, the last video we went through two opinions in Zarda, the Judge Bob Katzman for the Court of Appeals, and these two opinions, Katzman's and Lynch's opinions, are just about the one of the three cases consolidated in Bostick. So we went through this. I wanted to go back to this slide. Just again, the compare and contrast with Gorsuch's opinion is, I think, important here. You're not going to get a copy of the Katzman opinion or the Lynch opinion. I think it would help to at least have read those so that you have them, you know them for a reference point to handle the Gorsuch opinion and the ideas therein. Um, as I said last time, I think there's an important question here as between one and two and three on this list. This is a list of kind of approaches or themes or viewpoints. I don't even know what to call them. They're clearly distinguished, but they're three separate discussions that all support the result that Katzman wants to reach, which is sexual orientation discrimination or gender identity discrimination, maybe by extension here, is sex discrimination within the meaning of Title VII of the Civil Rights Act of 1964. The Gorsuch opinion is probably 98% one and 2% two, stereotype, and 0% three, associational discrimination. So why the Supreme Court structures its argument the way it does and whether it matters is going to be something to think about, right? Um, The Katzman leads with intentional disparate treatment because of sex. That's what this is. That's the entirety of Gorsuch's argument. It's more clearly and more logically developed in Gorsuch's argument, I think, but he doesn't talk about stereotyping and gender stereotyping or gender norms. Um, and he certainly doesn't talk at all about a social associational discrimination. So we went through Lynch's detailed reply to this. I think Lynch's opinion is respectable and worthy of respect and careful consideration. He's not a bigot. He would like to see equality and equal concern and respect for LGBTQ people. Says that repeatedly. He just doesn't think the statute's properly interpreted to include sexual orientation discrimination. So, should do a slideshow here. I also said last time that if you want to organize your notes or you're thinking about an opinion, judges and justices often will help you with Roman numerals and subheadings, and you could use those in your own writing. They keep you focused on the blocks of your argument using subheadings. Um, so, Gorsuch's opinion is our first task today, and then I will talk briefly at the end of this video about some concerns or questions we might have. Um, he very briefly goes through the three cases. There's the Zarda skydiving case, which is the facts are a little odd there. Bostick is more straightforward. He's a social service worker. He's a good worker. He's employed and doing his job very well. And somebody finds out, a private citizen finds out he's in a gay male softball league, and they report this to his superiors, and he's terminated for unbecoming conduct, whatever that means. Clearly, just obvious discrimination based on his sexual orientation. Stevens is it's a Michigan case. She's a trans woman who was presenting and working as a man at a private funeral home, and when she decides she wants to live and love as a woman, she informs her employer, and the employer eventually, after some communication, says, "Well, this isn't going to work out. Um, uh, we're not going to have your job for you after you have a leave to go do something. You're fired, basically." Um, I would note here, just in passing, we'll get back to this, that it's a very sparse, bare bones. It happens in a page or two, very dry. um, Statement of the facts. It's like what you get in law school and on an exam. The life and the details, the kind of things that we got from those Gillian Thomas chapters about the Hopkins case, the richness, the texture, the pain, the struggles, all of that's um, filtered. The facts are kind of skeleton, stick figure facts. Why is that? We can talk about that. We will in a minute. The decision is 6-3, and it's a bit of a surprise because, um, the balance of power on the court is 5-4 in a fairly conservative direction. By now, President Trump, during his first term, has appointed Neil Gorsuch to replace Scalia and Justice Brett Kavanaugh to replace Justice Kennedy, who was the swing justice. We have Alito and Thomas. Roberts is fairly conservative, and you might expect him to be fairly conservative on a statutory case. Not, so it's a strange result, and it's a surprise. It's 6-3 to conclude that if you discriminate against someone based on sexual orientation, or with the Stevens case in the mix, gender identity, we could say there's a shorthand for it. Sexual orientation would be SO, gender identity would be GI. So SOGI discrimination, you violate Title VII. Um, and so it's generally celebrated by LGBTQ activists as a interesting and valuable decision, a win. Um, what to make of it? Well, again, the Roman numerals on page 4 of his opinion, and you will have this opinion available to you. Very important page, because here Gorsuch lays out what he's going to do in this part of the opinion under Roman numeral 2, which is the heart of the argument. And he says, here's my plan. We're going to have to look closely at the language of the Civil Rights Act. He makes a great deal of logical syllogisms, of logical analysis, of hypothetical cases. We'll see in a minute. Then we'll take that analysis of the meaning of the statute and we'll apply it to these cases. That's part 2B. And then after that, in part C, we're going to talk about our precedents and whether our precedents are in line with what we think the words of the statute mean and must mean for us. So A, what's the key language? Because of sex. Now this is a little bit different from Katzmann's argument because it's theoretical and logical. What does that mean? Because of sex. Because of me could be on account of, and he gives you this idea of but for causation. Um, he loosens this up a little bit because but for causation means if you take an element out, the event or action doesn't happen. There could be multiple causes, but if you remove the but for cause you're looking for, then you're hypothesizing that the action or event wouldn't happen. But it is true, there can be multiple but for causes um, of an action or an event. He says somebody intentionally burns a neighbor's house down. They may have many reasons for doing so, right? But the fact, um, you know, doesn't mitigate the importance of any one of the but-for causes that go into an action or an event. This can be and has been a sweeping standard. This is a point that isn't made below. Um, how sweeping this has been and how the unanticipated applications of sex and because of sex in Title VII say sexual harassment wasn't anticipated, gender stereotyping wasn't anticipated, but they're in there. They're embedded in the statute, right? It's precisely because it's a sweeping standard. How and why is it a sweeping standard? Um, Congress, well, employers can't say it's not sex, but it's sex plus another thing, right? They can't defend that way, as in Phillips. They can't say, oh, we've hired 70% of women for 70% of the people hired for these jobs in the factory are women. We're not discriminating based on sex. We're just not going to hire women with small children. That's not a defense. Congress could have said, but did not say solely because of sex. That would be a different standard, much less sweeping. Um, Congress could have said, but did not say, primarily because of sex. That would be broader, but not as sweeping. This is Gorsuch's argument. In 1991, Congress amended Title VII and made it even broader by saying if sex is a motivating factor, it violates the law. Gorsuch says, well, we don't have to fuss about that because either one will do it here. This is a key point, right? So the employers the multiple but-for causations is one building block of the argument. A second one is this. The employers want to respond that this is not discrimination based on sex, it's discrimination based on sexual orientation or SO. The employers say, can't just change Bostick's sex. We can't make him a woman attracted to men. We'd have to change his sex and his sexual orientation. So if he were a woman, attracted to women, we'd fire her, and we'd be firing her for sexual orientation, not because of sex. So see, because we treat men and women equally, maybe equally badly, but equally, this is not sex discrimination, but rather sexual orientation discrimination. Gorsuch's answer to this is included in the Katzman opinion. Katzman doesn't put a neon sign around it. Gorsuch does and does early on. Title VII uses this word individual 3 times in the relevant provision, right? So the employer in the example above, who would fire a gay man and a lesbian equally, violates the law twice, right? Because this law means individuals are protected from discrimination because of sex. Everything depends on what because of sex means, but it runs to the individual. It's not a group comparative thing. It's the basis upon which the employer can't discriminate or harm the individual, right? Um, so even if it's both sex and sexual orientation, and clearly it is, then it still violates the law. It's a logical proposition, right? So an employer who fires a man for being feminine and a woman for being masculine likewise violates the law twice. Or he's great at these little law professor hypos, right? I fired her not because she's a woman, but because she's a woman and a Yankee fan. This is like I fired her because she's a woman and because she's attracted to women or gay. Same thing. She's still being fired in part because she's a woman. So mixed motives don't matter as long as sex is involved. So we come to this conclusion. Um, the status or conduct associated with these categories, homosexuality and transgender status, not relevant to employment or employment decisions, right? Um, and it's covered because it's impossible to discriminate against the person for being homosexual or transgender without discriminating against that individual. Also, in addition to based on sex. And then part C, so he's done the meaning of the because of sex. He's done how it should apply to um, sexual orientation and transgender status. And now he's going to talk about some precedents. And he talks about 3 large ones, 2 of which you read, 1 of which you did not, Phillips, Manhart, and Oncall. Um, Commentators have remarked upon often the absence of Price Waterhouse and Hopkins here and the idea of gender stereotyping. It's not there. That's a little odd to say the least. I mean, we should at least think about what to make of that. And maybe you don't make much of anything of it. I'm not sure, honestly. But it is worth noticing that Hopkins is not part of the body of law he wants to talk about and develop, right? What are the lessons of these three cases? Again, you can't relabel it and add a factor like motherhood in Phillips or life expectancy and not sex in Manhart. Um, so sex need not be the sole or even primary motivation or cause. He's established that. And treating males and females equally as groups is not a defense. Um, okay. So a transition, Roman numeral three. Here he's going to take up and respond to counter arguments, a good strategy when you're trying to persuade somebody of something. Um, one claim, and this is true, and Lynch makes a lot of it in his dissent. People understand that when you talk about sex discrimination and sexual orientation or gender identity discrimination, you kind of mean different things, right? They're culturally, socially, they're different categories, right? And then the employers present this odd hypothetical, and they want to make this point that it's sexual orientation, not sex. Imagine an applicant for a job, and there's a box, and it says, "Are you an LGBTQ plus person?" And then the applicant's required to check that box, yes or no. But then the employer arranges to expunge any information about whether the person checking that box is male or female. See, we don't want to hire any LGBTQ people, but we don't even know whether this person's a man or a woman. So this is not because of sex, right? Sex has been filtered out mechanically here. Um, we don't need to know the sex assigned at birth. Um, Gorsuch responds with a different box that says, you have to check this box, and it's yes or no. Are you either black or Catholic, right? So race, you can't discriminate based on race, and you can't discriminate based on religion. Is this analogous? And the employer need not know whether the person checking the box is black or Catholic or both. Um, again, it violates the law twice, right? Um, you can't do that. You can't say, are you black or Catholic and act on the basis of it, right? So um, employers have another claim that I think is weightier, and Jerry Lynch thinks this is kind of crucial. Congress didn't list sexual orientation on the list, and of course it wouldn't do that in 1964. Um, and it's also been brought up a number of times. Um, So it's not there, and it's for Congress to put it there or not put it there. Well, Gorsuch, again, the sweeping standard, a lot of things not listed or contemplated um, have become a concern because they're entailments of the sweeping standard, right? Sexual harassment is the main example he uses here. Moreover, just because Congress didn't include it doesn't mean it's not included in sex if there's a logical entailment. And silence, thinking about things and not acting on them, nothing can be inferred from silence. That would be congressional silence and not responding favorably to proposals to add sexual orientation to the list of protected classes. The employers say, obviously, again, we're repeating ourselves here, men and women can suffer adverse consequences equally. Um, Now, I don't know, this was a little puzzling in this part of the opinion. You might want to take a look at it. His answer to that is you're going to boil down to stereotypes. So, maybe this does silently, like when you say that, you're still stereotyping men and women because of sex, and the stereotype that's being expected is heterosexuality, or you're not a man if you're gay. everyone should be heterosexual. You're not really a woman if you're a lesbian. Um, and then again, the logical point that you can't see that or act on it unless you take sex into account, unless you at least notice the sex of the person. So sex is one of the factors, and here, but for cause. Um, there's an implication of stereotyping here. But he doesn't talk about Price Waterhouse here at all. And the stereotype idea is sort of referenced in passing. Um, so again, the employers are saying nobody in Congress had this in mind at all. And if anybody asked them to contemplate it, they would have laughed. Um, well, okay, but if the way we interpret the statute is what they would have thought in 1964, then there's a lot of important cases we'd have to overturn. Phillips, Vincent, Hopkins, we're not going to do that because those cases make sense. And the employers then point to, and this argument usually comes in legal argumentation at the end. It's about not about what the law requires looking backward, but looking forward. What are the practical implications of this? What are maybe the unintended consequences of this? What harm is it going to do in the future? And they say that Gorsuch's analysis places sex segregated bathrooms, locker rooms in question, sex-based differentiation for dress codes and grooming codes, those are put in question. Maybe some other things where this idea, this understanding of what sex discrimination includes could have other consequences. And, the lawyerly answer to that is there'll be time enough to think about that later. This hasn't been argued, this hasn't been briefed. No, that's not the case before us. We're courts, right? And even the Supreme Court wants to convince you it's a court. It only decides concrete cases in a concrete context. Those cases aren't here. So, and if somebody's acting on the basis of religious convictions in being homophobic, that presents a different problem. Gorsuch is leading proponent of making free exercise of religion a kind of gives you a pass on obeying anti-discrimination laws. So, he's just going to evade that topic of what are the implications. All right. So that's the summary of his opinion. I want to raise a couple questions for you to consider going forward here. And I think probably the main area of contention about this case, I mean, well, there are lots of possible areas of contention. If you think Lynch makes the best argument, then why is that? And does he have his head in the sand when he says it's really for Congress? Congress should do this. But another big area of contention is this one, and it has to do with the distinction that we make between a result in a case and the opinion that justifies it, and whether and how the content and character of that opinion might matter, even though, we have the result. So after 1967 or so, nobody credibly says Brown v. Board was wrongly decided. They do say it was wrongly decided for 10 years afterward. But even if you like the result in Brown, is the opinion, the short 13 paragraph public facing opinion in Brown, is that the opinion for you? Does it give us a persuasive account of what the harm really is? Is there any clarity about it, or could it be interpreted in five different ways plausibly? Well, actually, it could be interpreted in many ways plausibly after it. There was a battle over the meaning of Brown. Similarly with Roe, which we're going to look at, even if you're ardently pro-choice and maybe more pro-choice than the median point for public opinion, is Blackmun's opinion in Roe the argument for you? Is it the best possible argument? It has a kind of a clunky, conclusory quality to it, and one can't call it really other than the fact that it expands protection to terminate an unwanted pregnancy based on a liberty argument, autonomy argument. One can't really call it feminist. Doctors are very important in Blackmun's treatment in Roe. So is there another way to frame Roe? or would something less sweeping and better defended embed more than it did, and so on. So opinion and result are different. We can say of an opinion that's very well crafted. That's really remarkable. I would say that of Jerry Lynch's opinion in Zarda, that it's incredibly well crafted, very well argued, completely respectful of the argument he wants to refute, states the opposition fairly and responds to it. But I don't agree with the result. And I don't. I think Katzman has a better argument, but so we make this distinction. What's Gorsuch's approach? It's formal. It's a formal analysis of the words of a statute. It's a textual approach more than anything else. Um, it's about logic. Um, and some people find it unsatisfying because it's such a does its formality and its skeletal presentation of the dispute, does it take away the power? Does it, if opinions from the Supreme Court can reshape understandings and culture, is he's I don't think he's trying to do that. Maybe he shouldn't. Um, but the criticisms of the opinion, if you agree with the result, you might be uncomfortable with the opinion. He doesn't seem to want to talk about these persons who are involved here. He's almost like doesn't really want to touch them. They're little stick figures on a page. It More broadly, he doesn't do what one might do in this case, which is talk about the history of prejudice and phobia and oppression and subordination, just meanness toward LGBTQ people. The history of those groups of people is the history of the closet, a silencing. Um, you might write that history on the parallel track of race and sex, where you might write the history of civil rights, Black freedom struggles, or you might write the history of women's struggles as a way of providing a justificatory ground for the legal analysis, right? That we're not writing as if we just landed from Mars. We're writing against the backdrop of our actual history, and that history might inform our analysis. There's none of that. He doesn't say anything about that at all. Um, Another concern, as I mentioned before, the failure to cite and go into and discuss Hopkins when he does precisely that with Phillips, Manhart, and Onkal is strange and arguably troubling. It's puzzling. Does it matter? Why does he want to downplay or shy away from an anti-stereotyping approach as opposed to his uh, elaborated and developed formal textual approach to the statute? What is that about? Well, the argument for being worried about it is because the argument for the result fails to address the real nature of the harm, does it? The real nature of the harm, this argument would go, is that discrimination against LGBTQ plus people is rooted in and justified by their perceived and or actual violation of the patriarchal norms that pervade our society. I don't think Gorsuch much cares about those patriarchal norms. He probably thinks they're okay. I don't know. But if you think homophobia is grounded in misogyny or sexism, then what you're not getting is a declaration of rights here. You're not getting a kind of an acknowledgement of that yes, Title VII covers individuals, but the harm here is that some groups are doing harm and maybe taken advantage of by using and scapegoating other groups. Nothing like that in the opinion. Now, if you like the result, maybe you should count your blessings because it's kind of an unexpected result from a conservative court. And we've seen that opinions can have complex and multiple effects going forward that are not so easy to contain or predict. We don't know. We just don't know. Um, and the second thing you might want to think about is the application in other contexts where Gorsuch says, I'm not going to talk about that. I don't have to, and I'm not going to. Um, Katzmann's approach, which focuses, gives almost equal time to anti-stereotyping ideas, and you can't uh, discriminate against somebody based on with whom they associate. Um, would that approach have more life outside of the Title VII context or not? I asked you to think about whether there was any real difference between um, intentionally disparate treatment and the text that says because of text, that analysis, which is almost entirely Gorsuch's analysis, and a discussion of how this discrimination involves impermissible stereotyping, which would invoke a discussion of gender and gender norms. Any difference? They do lead to the same results. I'm not sure. What other contexts? Well, we have a number of cases where people are denied access to bathrooms that comport with their current gender identity and presentation and tell them to use the bathroom of the sex assigned at their birth. Where I teach, and probably at Rutgers, there's usually three options. There's a sex segregated option, and then there's an option that anyone can use with a lock, and that tends to satisfy people well enough. It might be demeaning to tell, say, let's say the Michigan case and these cases, the Stevens case, if say the employer in the funeral home didn't fire her, but said, okay, I'll tolerate, I'll hold my nose and tolerate you, but everyone has seen you here presenting as a man for years. You have to use the men's room. You can't use the women's room. All right. Well, um, I think it's a logical extension of Gorsuch's argument that that violates Title VII. I'm not sure that Gorsuch does. Would it depend on how demeaning we think that is? Um, Dress codes and gender identity, that's going to be another context. Um, and usually sex differentiated grooming standards and dress codes have been upheld as not terribly disadvantaging to any group or person so far. And then, we have sexual orientation and gender identity discrimination in the military, and that's front and center and unresolved since President Trump issued an executive order banning trans people from serving and required their discharge if they are serving. And the lower courts put a stop to that temporarily. Lower courts said, no, that violates the Constitution because we first of all, what is biological sex? And second of all, it's hard to imagine a reason for doing this to people other than to demean them. You're actually demeaning them on the face of the order. You're saying they're dishonest, they're liars, they have bad character. That's why we're kicking them out. So trans people, by definition, have bad character. I would think you don't have the background of the case law to handle this yet, but the lower court said, well, you're likely to win this case to block that, right? And it's an action by the president in the military context. You're likely to win. So we now order the executive not to implement this policy pending litigation, pending a trial and an outcome, and pending appeal. The status quo before you did this should remain. It's a temporary injunction, then a preliminary injunction, right? And that stopping of Trump doing that was stood through the Court of Appeals. But then when the administration went to the United States Supreme Court in May of 2025 in a 6-3 order, nobody wrote an opinion about who would be likely to win the case and why. This is called the emergency docket or the shadow docket. No argument, no law, just an emergency application. And the Supreme Court, 6-3, lets the policy go into effect pending the outcome of litigation. So people are going to get hurt. People are going to have been discharged. Gorsuch joins, he votes to let that policy go into effect. I don't know what meaning or lesson or ideas you could derive from that. I'm just stating the fact. May mean nothing. The court may decide in favor of the plaintiffs when the court hears it again in 3 years. But we don't know, or something else might change. We don't know. But um, this is also related to the opinion that justifies the result and that dichotomy. So I think you should, think about that. Um, should someone defend Lynch's approach, which is we're a democracy, Congress is in charge of this issue, and Congress hasn't decided it. We could invite Congress to decide it, but we shouldn't decide it. We shouldn't amend the statute because we think it's right to amend the statute. Everything depends on what the statute is and how you go about interpreting it, right? As you can see now. Um, and again, this would be a new constitutional case if Congress passed a law that said singled out sexual orientation as not protected. Would the 14th Amendment, which does include a ban on sex discrimination, as we know from VMI, um, what would that argument look like under the Constitution? Would Congress's explicit rejection of sexual orientation. That would be a law that says, we hereby declare that sexual orientation and gender identity are not protected under Title VII. You can do what you want to those people. Um, would that be unconstitutional under the 14th Amendment, and would the court say so? Um, right. Okay. So I'm going to stop there. I know these went on much longer than most people have tolerance for these days, but again, I just wanted to give you more food for thought about the assignment and the opinion for Wednesday.